Okay, stay with me here. Because what I'm about to walk you through is not noise, it's the signal. This is one of those moments that doesn't feel historic while it's happening, but later we will point back and say this is where the trajectory shifted. Early this morning, while most Americans were scrolling past headlines without noticing the implications, the United States Supreme Court made a decision by not making one. And silence in this context is not neutrality, it is action. Here's what you need to understand before anything else. The Supreme Court was presented with a narrow window to intervene in a rapidly accelerating constitutional crisis. They were asked to step in, pause the clock, and assert authority over a case that directly challenges the scope of presidential power. They declined to do so. This wasn't a denial with explanation or reasoning. This wasn't a scheduled hearing or a call for further briefing. This was silence, procedural silence. The kind that lets lower court rulings stand without resistance. And in the judicial system, that silence has consequences. Just hours earlier, the Federal Appeals Court in Washington, D.C. had issued a ruling that didn't just deny relief. It dismantled a legal doctrine many assumed still existed. That doctrine was the idea that former presidents operate above criminal accountability for actions taken while in office. The appeals court rejected that assumption outright. The timing matters more than people realize. Trump's legal team filed their emergency request late at night, signaling urgency and expectation of intervention. Less than 8 hours later, the appellate court responded with a unanimous rejection. No oral argument, no hesitation, no ambiguity. When courts move that fast, they are not debating. They are declaring. The message was simple and devastating. This legal theory does not survive scrutiny. And now, with the Supreme Court choosing not to intervene, that declaration becomes operational reality. Let's slow this down, because this is where most coverage loses the plot. The Supreme Court didn't rule in Trump's favor, but they also didn't block the lower court. That means the appeals court ruling stands as binding law for now. And that ruling fundamentally reframes presidential immunity. For decades, presidential power relied not just on written law, but on assumptions. Assumptions that criminal prosecution would be politically unthinkable. Assumptions that accountability would be handled through elections, not indictments. Those assumptions just collapsed. The appeals court drew a hard line. They ruled that actions taken to remain in power after losing an election are not official acts. They ruled that such actions fall outside the protective bubble of executive authority. And they ruled that criminal charges based on those actions can proceed. This is not a symbolic moment. This is procedural, mechanical, and binding. It activates timelines that cannot be paused by rhetoric or political pressure. And that's where the danger accelerates. Because once immunity is stripped away, the legal system does what it always does. It moves forward. It sets deadlines. It schedules trials. It compels testimony. And it does not care about election calendars. The Speedy Trial Act is now in play. That statute doesn't negotiate with campaigns or poll numbers. Once the immunity question is settled, the countdown begins. And according to the calendar, that countdown has already started. Judges don't bluff when they invoke the Speedy Trial Act. They invoke it because delay is no longer justified. And once invoked, it becomes a legal obligation, not a suggestion. That's the trap closing right now. Trump's team knows this. They've known it since the emergency filing failed. They understand that every denied motion removes another escape route. And they understand that the Supreme Court's silence just eliminated the most powerful one. Now ask yourself why the court stayed silent. This wasn't a liberal majority ignoring a conservative plea. This was a conservative-dominated court choosing not to act. Chief Justice Roberts, known for guarding institutional legitimacy, did nothing. So did the justices Trump himself appointed. No shadow docket maneuver. No emergency stay. No signal that intervention was imminent. That silence tells you something profound about how this case is being viewed internally. Courts intervene when they believe a lower court has made a grave error. They intervene when institutional damage is imminent. They intervene when precedent is being recklessly broken. They did not intervene here. That means, at minimum, the court does not believe the appeals ruling is obviously wrong. And at maximum, it means they are prepared to let the criminal process run its course. Either way, the implications are enormous. This is why cable news coverage feels inadequate. Because this isn't about personalities or partisan drama. This is about process overtaking politics. And process is the one arena Trump has never controlled. Once prosecutors are cleared to move forward, everything changes. Witnesses are locked in. Evidence is frozen. Timelines become rigid. And public messaging becomes legally dangerous. Every post, every statement, every threat becomes potential evidence, not opinion evidence. Prosecutors don't respond to press conferences, they respond to records, and records are being created in real time. We are now in a phase where restraint matters more than spin. And restraint is not something Trump has ever demonstrated under pressure. That mismatch is what makes the next phase so volatile. Because the legal system doesn't react to intimidation by backing off. It reacts by hardening positions. Judges tighten rules. Prosecutors expand scopes. Investigators widen nets. And this is happening across multiple jurisdictions simultaneously. Washington, D.C. is not operating in isolation. Georgia is watching. Florida is watching. New York is watching. Each case is independent. Each has its own evidence, statutes, and exposure, and none of them depend on political outcomes to proceed. This is convergence. Years of investigations, testimony, recordings, documents, and filings are now aligning into a single narrow window. And once that window closes, there is no reset. The Supreme Court's silence didn't calm the system. It accelerated it. It removed the last expectation of institutional rescue, and it forced the process to continue unimpeded. Stay with me because this is only the opening move. What comes next is the activation of timelines, witnesses, and consequences that cannot be undone. And once those wheels start turning, even the presidency cannot stop them. Now here's where everything accelerates and there is no off-ramp left. Once the appeals court ruling stands and the Supreme Court refuses to intervene, the legal system shifts from theory to execution. This is the moment when arguments stop mattering and calendars start controlling outcomes. And calendars are unforgiving. Judge Tanya Chutkan is not waiting for political convenience. She invoked the Speedy Trial Act. Because the law requires momentum once, immunity claims collapse. That statute doesn't care about rallies, primaries, or party strategy. It cares about days, deadlines, and compliance. The appeals clock is already ticking. Once the final opinion is issued, prosecutors are legally empowered to push for an immediate trial date. And that date, once locked, becomes extremely difficult to move. This is why Trump's legal team is running out of air. Unanimous appellate rulings are rarely overturned. Courts treat them as settled unless something extraordinary intervenes. And the Supreme Court already passed on that opportunity. That silence effectively seals the lower court's authority. Behind the scenes, prosecutors are not debating hypotheticals. They are finalizing witness sequences, evidence presentation, and jury strategy. This is not preparation for a future possibility. This is preparation for an imminent courtroom battle. The witness list is devastating. Trump's own vice president, his own chief of staff, his own White House counsel, people who were in the room, not outsiders guessing motives. These witnesses are not speculating. They are recounting conversations, directives, and decisions under oath. Their testimony is corroborated by text messages, emails, call logs, and video evidence. This is why delay has become the only strategy left. And delay is failing everywhere. Georgia is operating independently with state-level charges immune to federal immunity claims. Florida's classified documents case carries its own exposure, including obstruction risks. New York adds another layer of financial and legal vulnerability. None of these cases depend on each other to succeed. Each one advances on its own track. That means even one conviction triggers irreversible consequences, and that reality is now unavoidable. Trump's public response is making everything worse. Attacks on judges, attacks on witnesses, warnings of chaos if prosecutions continue. These statements are not political theater anymore. They are potential evidence. Every post is archived. Every thread is logged. Every escalation strengthens prosecutorial arguments about obstruction and intent. This is the paradox Trump cannot escape. Washington understands this risk. Law enforcement agencies are not guessing anymore. Capitol Police, the FBI, and U.S. Marshals are operating under elevated threat assessments. January 6th rewired how seriously they take rhetoric. Security preparations are already visible. Courthouse protections are increasing. Witnesses are being shielded. Judges are being guarded. The system is bracing for volatility. Meanwhile, the political fallout is fracturing the Republican Party in real time. Loyalists are doubling down while pragmatists are quietly distancing themselves. Silence from leadership is becoming louder than defense. Poll numbers tell the brutal truth. A significant portion of Republican voters say they will not support a convicted nominee. That number alone changes campaign math nationwide. Senate and House candidates know this. Then there is the unresolved constitutional question hanging overhead. The 14th Amendment Insurrection Clause does not require a criminal conviction. States have already acted on that interpretation, and the Supreme Court will eventually have to rule. This is why allies abroad are watching closely. Domestic instability at this level has global implications. Adversaries read weakness as opportunity. Allies read uncertainty as risk. Beyond Trump himself, this moment reshapes presidential power permanently. The assumption that former presidents are untouchable is gone. The legal wall that protected them has cracked. Future presidents will operate differently because of this. The justice system does not negotiate. It does not pause for optics. It does not bend to anger or intimidation. Once it moves forward. This is no longer about whether Trump likes the system. It is about whether the system applies to him, and right now every signal says it does. The next weeks are not speculative. They are procedural. Motions will be ruled on, juries will be selected, evidence will be presented, verdicts will be rendered. History will not remember the tweets or the outrage. It will remember the rulings, the testimony, and the outcomes. This is how accountability actually looks. So when people ask what moment changed everything, it won't be a speech or a rally. It will be this quiet sequence of court decisions and non-decisions. The moment the system chose to move forward. If you want to stay ahead of the headlines and understand what's really happening beneath the noise, subscribe to this channel. Turn on notifications so you don't miss what comes next. Because once this process finishes, nothing about American politics will be the same. Thank you for watching.